Well, joining us now in the studio with another In the Legal Know, Vincent J. Russo. And today, Vincent is going to help us understand the legal terminology when it comes to the players.
Right. Who are the players in your estate?
Yes.
And so it's really important that we understand the legal terminology of individuals who are beneficiaries of an estate. Mm-hmm. And what are they entitled to or not entitled to? So that's what we're going to cover today.
Okay, so we're going to start off with testator.
Yes, the testator.
Okay.
All right, a testator is a will maker. It's the person who makes a will. And so an individual wants to leave their estate, they sign a will, and they're the testator. When they pass away, they're also referred to as the decedent. If there is no will, then there's a separate proceeding to deal with it, and there are laws that come into play when there's no will involved. So point number one, control how you leave your assets in your estate by having a will.
Okay, be the testator.
And be the testator.
We are really in the legal know today, boy.
Okay.
Okay, next definition, surviving spouse.
Right.
And we need a definition for this. I'm surprised.
Yes, because there are legal rights that a surviving spouse has in the estate of a deceased spouse. Mm-hmm. So it's important that there's standing there for a surviving spouse. So, for example, if a deceased spouse has a will and leaves assets to other people, not the surviving spouse, then under state laws, that surviving spouse has a right to inherit a portion of the deceased spouse's estate. Another example would be if there is no will, then the state controls where the assets go. And there's a pecking order. It's called the intestacy laws. Mm-hmm. And a surviving spouse is right up there at the top, entitled to a portion of the estate. Also, as a surviving spouse, you may be entitled to pension benefits of a deceased spouse, Social Security benefits, and also veteran benefits, what's called aid in attendance. So if you were married to a veteran and he passes away or she passes away, the surviving spouse may be entitled to certain benefits.
Okay, let's move on. There is a distinction between children, issue, and descendants.
Yes. Okay, so let's start with children. All right, there are two types, two flavors. There are the biological children of individuals, parents, and also the legally adopted children. So as a child, here again, you may have rights in the estate depending on state laws. So they're standing there. Now, the distinction is sometimes lawyers will draft wills and they'll use terms like issue or descendants. Instead of saying, I leave my assets to my children, I leave my assets to my issue. And issue are lineal descendants. What that means in English, children, grandchildren, great-grandchildren, great-great-grandchildren, just going down the line.
Okay.
All right? So issue is a term that often is used in wills. Lineal descendants and issue are kind of interchangeable terms. Mm-hmm. And it's important because if you have a will and you leave your assets to 3 children, children have standing in that situation. Now, if that child, one of them predeceased, then there are laws called the anti-lapse laws that would say that if that child dies before the parent, then the children of that child step into the shoes of the deceased child.
Okay.
So these laws are applicable state by state. It's important to really understand the distinctions because lawyers will use those terms. I leave my assets to my children, my issue, or my descendants, and it could mean different things depending on the type of, depending on the state you reside in.
Okay, make sure you're clear on that. Now, the next one, minor. I think I know what this means.
Okay, so minor, legal status. A minor is a person who's not of age of majority in the United States, generally age 18. Mm-hmm. Here again, state laws could come into play. So when you're a minor and that person is a beneficiary of one's estate, that puts that person in a different position than an adult child because they cannot legally bind themselves to a contract, for example. They don't have the legal authority to make decisions. So now you need a guardian of that child. All right, so that's another person coming into play. Parents generally are the guardian of a minor child, but if the parents predeceased the minor child, then you need a legally appointed guardian.
But very, very often parents do appoint that guardian, right, in their wills?
Yes,
right.
Just in case.
Is there a difference between that award? What is a ward of the estate?
All right, so a minor would be a ward of the estate, but also someone who perhaps lacks legal capacity. So if someone was developmentally disabled and not able to really make their own decisions, they would be considered a ward of the estate. And here again, the court in a will proceeding will look at this and say that person needs somebody to make decisions for them, and that person typically is referred to as a guardian or a conservator.
Okay. That's where we're going to pick up next time. We're going to do this in 2 parts, right?
Yes.
Okay, so next time we'll be talking about guardians and how important it is to appoint a guardian.
Yeah, and we'll go over estate administrations and the terminology there, executors and trustees and beneficiaries.
Okay, we're going to do that actually a week from today. We'll see you on June 15th.
I'll be here.
Okay, thank you, Vincent.
You're welcome.